of the United Homeowner Associations of Bloomfield Township. I'm Richard Moxley, President. The state legislature passed a bill in the lame duck session of 2018 that would void all deed restrictions that are over 40 years old. This was to take effect in March of this year. The document was the MMTA, the Michigan Management Title Association. Is that correct?
It's called the Marketable Record Title Act. And I'll talk about it.
Okay. We only heard of this in June of 2018 from one of our members, Harris Inc., which I thank him.
Right.
The legislature has since pushed back the date 3 years. Today we have a title attorney, Steve Matta of Matta Blair PLC of Bloomfield Hills. He will address the effects of this act on your titles and deed restrictions. Please hold your questions until the end of this session and give your name and the address of your name and your association. Thank you. It's yours, Steve.
Thank you very much. And I thank you, Richard and David, both for inviting me to do this. You know, shortly after I got your invitation to come here, Governor Whitmer announced that bars and restaurants and theaters could reopen effective February 1. She obviously realized that if this many people were going to gather on a Saturday morning, that we're really out of entertainment options. If we're going to just sit here and talk about deed restrictions on a Saturday. So she realized we were desperate, but we'll go back to bars and restaurants next week. I'm very happy to be here, and I know many of you are active in your respective homeowners associations, and I congratulate you for being community-minded and civically responsible. But I do wonder whether many of you have even read or know fully your deed restrictions, your building and use restrictions. If not, I encourage you to print a copy out, keep it by your bedside. It's basically melatonin on paper. You'll be in for the best night of sleep you've ever had. But they, aside from being boring, are very, very important. You first encounter them, and many people do first encounter them when they buy a house in a subdivision, and you encounter them in an unusual way. You actually experience them. You drive into the subdivision, you see a nice sign, you see flowers, a flower bed nicely maintained. You look at the homes and you see, you know, how well the yards are maintained. You see few sheds in the yard. You kind of look around and you don't happen to notice a slaughterhouse or a tannery or a flop house or a gin house, things that are generally barred in those old documents. You know, and so you see the house and you like it and you buy it, but you don't really appreciate yet how that value has been enhanced by the deed restrictions that have been in place. You might even get a chance to see the deed restrictions as part of the closing. They are referenced in your deed. Generally, they are referenced as you take subject to the building and use restrictions, covenants, and declarations of record. Unfortunately, that reference no longer holds any value because of the change in the Marketable Record Title Act, and we'll talk about that in a minute. You now have to describe that by LIBOR and page specifically in order to reactivate those on a deed-by-deed basis, which could take forever, and that's one of the reasons we've been proactive in trying to address this issue. You may have seen in your title policy a reference to an exception to the title coverage for your building and use restrictions, because title companies generally don't insure that. They tell you, you're taking title subject to the building and use restrictions that are in document dated, say, October 1 of 1956 at LIBOR 1234, page 3 of county record. You can get a copy of them from your title company. Many people do, and you can acquaint yourself with them. You might even read them, and you might say, yeah, honey, we can't run that B&B here, and apparently I can't drink gin in the gin house, so we got to do something different with what we're planning. But generally, you don't do that. Most people don't familiarize themselves with these deed restrictions when they see them, or if they see them at all. But these conditions have been around the use of these type of conditions have been around for centuries. In fact, I'll tell you this, our Supreme Court has said it is a fundamental principle, both regard to our citizens' expectations and in our jurisprudence, that property holders are free to improve their property. We have said that property owners are free to attempt to enhance the value of their property in any lawful way, by physical improvement, by psychological inducement, by contract, or otherwise. And covenants running with the land are legal instruments utilized to assist in that enhancement. A covenant is a contract created with the intention of enhancing the value of property, and as such, it is a valuable property right. Some associations are voluntary, some are mandatory, but in every situation where there are building and use restrictions, they are designed for the purpose of enhancing your collective value in your respective subdivisions. Many of them differ, obviously. Some subdivisions will say homes have to be 1,000 square feet. Some will say 3,000. Some will say you can have a shed, some say you can't. But most of them are very, very similar in how they operate. So if these are so old and we all know about them, why are we here? Well, as Dick mentioned, in December of 2018, the legislature passed a change that was effective March 29th of 2019 to what's called the Marketable Record Title Act. Now, why would they do that? What is it? It basically says if you have an unbroken chain of title of record for any interest in land for 40 years, you have marketable title. And it's only subject to claims that are not extinguished by the act inside 40 years, or if it's stated in your title when you got it. Now, again, it has to be stated specifically by Liber and Page in your title. So a general reference to building and use restrictions is not going to save your building and use restrictions on that particular property. Plus, it would be by each individual deed, and that might not happen for a while. Some people have been in their homes longer than 40 years. In any event, recently, there's been some lobbying going on about this. For example, the condominium associations, who have a very active lobby, have tried to get the legislature to pass an exception that doesn't require condo associations to re-record master deeds and bylaws and things of that nature. So far, I'm told by the people who are behind these bills that is probably going to get passed. What they have been successful in doing, though, is getting an extension on the requirement that you do it within 2 years of 2019, which would be coming up here this March 29th. They've given us till 2024, March 29th of 2024. Now, I guess we should pack up and wait, right? No, that's not what we should be doing. That reprieve is going to give you an opportunity to do some very important things. First thing you ought to be doing is getting your building and use restrictions and looking at them very closely to see what needs to be modernized. For example, if you have 30 homes in your subdivision and there are 16 sheds existing and you have a prohibition in your building and use restrictions for sheds, you may want to change that because it's probably not going to be enforceable anymore. And instead, what you might look at is, well, if we're not going to be able to prohibit sheds, what we can do is limit the number of sheds, the size of the shed, the materials used on the shed, the maintenance of the shed, and we can do something to enhance value that way. And that's just one example. I mean, there are many other examples of what you might do to modernize. For example, you may have a voluntary association or voluntary payment association, and only half the people are contributing to the annual party or the flowers or whatever else you need to maintain. And you may want to make that mandatory. There may be several building and use restrictions that are on your document that are so old that they violate current anti-discrimination laws against race, creed, color, national origin, things of that nature. Those should be eliminated. The other thing you need to understand is it usually takes a vote of 66% of the subdivision owners to approve an amendment. So that is not going to happen overnight. I have one that's been going on for a year now. It's been COVID, but it is very difficult to get consensus on a new draft, new restrictions, circulate them, debate them, revise them, and get everyone together to vote on them, particularly in COVID, but in general. It's just hard to get everyone to do that. And many of you may know that from the meetings that you hold or conduct with your respective associations. But I would encourage you to use this time wisely and do not wait till the last minute. It will go by quickly. The other thing you need to know is if you do this, if you take the action now, you modernize your restrictions, you vote, you get them passed, and you get it recorded, that starts your 40 years. And you don't have to wait till 2024 to worry about whether or not they're going to give you an exception or not. That will take care of the problem right now. And it'll do it for everyone in the subdivision, not on a piecemeal basis. If you did it on a piecemeal basis, for example, any individual can enforce the deed restrictions. But if I wanted to do that as one homeowner and I had 100 other homeowners in my sub, I would have to record a document against everyone in that sub. That's $30 times 100 homes. I'm not going to pay that. Your association, on the other hand, can record one document, but depending on the content of your building and use restrictions or your declarations. Depending on that, they can hopefully record one document against all the units at one time, and that's $30. Renew the restrictions. I encourage you to modernize them. I encourage you to visit them, and I encourage you to call me or David or Dick or anyone in your group to talk about how you can modernize them and what to do to get them up to speed. I'm open to any questions you have. There's apparently when you click on the top or bottom or wherever your screen is set up, there's a way to select raise your hand. And if you can do that, I don't know if I'll be able to see it or if it'll be Richard or David that can see it. I'll call on you if you have a question.
Yes, at the very bottom of the screen, if you cursor down to there, you'll have a pop-up tray. To the right is a login as reactions. If you click on that, you have the ability to raise your hand, and it would give us a little bit more control other than having everybody rushing to the gate. Example on mine.
Dave, I see your hand. Yes, I do see that raised.
My hand.
Okay.
I do. Now I might have to keep scrolling. I see.
No, wrong Dave.
Dave Richter has a question.
Oh, okay. Can you hear me?
Yes, I can hear you.
I have a couple. Let's see. You mentioned voting on the covenants. We've had that's never, I've been the treasurer now for 5 years and been going to meetings off and on for 10. And usually the covenants don't come up much. But we have recently modified our bylaws, and people are more concerned. What is the difference between the bylaws and these covenants and restrictions?
Sure, fair question. So the bylaws govern the actual entity of the association. They'll determine how officers are voted in, how money may be handled, how budgets are formulated, how budgets are circulated. They'll keep you. With your annual reports filed with the state, they make you compliant with the necessary corporate requirements of your structure. The declarations and restrictions run with the land. Those are binding just by virtue of buying the property, assuming they remain valid despite this act. They're mandatory and enforceable by anyone, not just the association. Each individual homeowner has a property right there and can enforce them. So they are two separate things.
The other question you mentioned that I got the impression then that the title company may or may not disclose these covenants.
They almost routinely do. I haven't seen one without them. If they're there, they'll find them. Usually because title companies should be searching back to the plat. They get the plat, they see there's a reference to an association or a deed restriction in it. Most of the title companies know the subs anyway, even if they're going back to just 40 years at this point. But they should be going back to farther than that. Almost always they're disclosed on a title policy. But as an exception, you should understand that they are listed as an exception to their coverage because they're not going to enforce those deed restrictions for you.
Okay, thank you very much.
Okay. That's where you'll find them though. And many nowadays, because of everything being electronic the way it is, a lot of times there's an embedded link right in the commitment when you get it that you can click on it and pull up those actual restrictions. I don't know what happened with the screen there.
Yeah.
He decided to schedule something.
Yeah, somebody's screen took over there. I don't know what happened there. That's Karen's screen, apparently.
Karen's sharing her screen.
All right, are we still,
Karen, do you hear us? You're sharing your screen with us.
all right.
No, Moxley's there.
The problem is I can't see anyone else to ask a question. I know there was another David there.
You're coming
I
through.
will try to get out of this. I'm going to reboot. I did something wrong. Sorry.
Just hit stop sharing.
Yeah, right.
Okay.
You have stopped
Okay.
sharing there?
I was the other David with a question. It's David Thomas.
Yes.
Bill Savoy allowed a very elaborate shed to be built on a property. They originally were supposed to get neighborhood comment on it, then they withdrew the neighborhood comment. Next thing I know, the shed's up, and we have bylaws that prohibit sheds.
You mean you have restrictions that prohibit sheds, correct?
Yes.
Yeah.
Yeah.
So I don't know what happened here. Let's see if I can turn that around. There we go.
Hey,
so-
back to normal.
There we go. So, and I apologize for the light that's streaming in my office as well, but the board really should be taking action then. You should be sending them a letter and informing them of the violation of the restriction. And, if you let it go, what's going to happen is you're going to have sheds everywhere now, but you won't have any enforcement ability. So you really do need to take action to enforce that restriction as soon as it's a violation. And I would encourage you to do that right away. They really needed to get some type of approval in advance if they were going to get it. Is it violative of the restriction in general or size and material restrictions? Is it?
This is almost the size of a small house. I mean, it's a two-story structure. They built this thing. They never got the neighbors next adjoining it to sign off on this. They originally set it out, the notifications, and they kept postponing the date. And the next thing I knew, it's up.
Yeah. So part of that problem is they probably got a local building permit, and they thought that was enough. And many people confused that.
Oh, no, it was going out. It was going out all the time. This is during the election period. And all of a sudden, no more meetings, and the structure went up.
Yeah. So it shouldn't be. You have to enforce it. I would send them a letter and
Okay.
tell them to take it down. If they don't take it down, you have injunction rights. Restrictions are enforced by injunction. The court will, if there are no other sheds that have somehow popped up enough to violate, the restriction to the point where it's no longer enforceable, and that would take a lot. If there, a one or two is not going to matter, but a consistent violation will void the restriction, which is why you have to be vigilant in enforcing them in the first place, and the court will enforce it. They'll order it taken down.
They had to put at least 80,000 into this thing.
Oh,
It's like it is literally like a small house. It's a two-story brick construction. It's like a small house.
Has the municipality been out there to see it?
The municipality backed off of covering anything on this thing. It was a
Yeah.
friend of Leo deal.
I see. Well, I would encourage you to get your board to take action for sure.
Okay.
Lawyer.
Okay. I see Cameron has a hand up.
Yes, thank you. So we have deed restrictions, which we've actively enforced over the years. We've actually had one action some years ago to enforce those deed restrictions. So my question really goes to the issue of what kind of language, and when there was language in our deed restrictions for how to deal with the enforcement process. The first step of which is going to arbitration and the rest of it, and we did all that.
Okay.
And we were successful in doing it. But my question is, if we were to modernize the deed restrictions, which I don't think we'll do because we know what a battle that would be.
Right.
But if we were, what kind of language, modern language, is typically put in for the enforcement actions in deed restrictions?
Well, so do you collect assessments?
We do. We have a mandatory maintenance fee every year. It's
Right.
not very much, but in the primary purpose is actually we've been accumulating money in order to face the possibility of having other actions. One of the wake-up calls on this is that it's very expensive, even when you know you're going to win, to do it. The first action,
Right.
which involved setbacks, which is our primary issue, was it cost us roughly 15K. So we now have as our mission to keep to try to get to a balance in our fund of roughly 30K, so that any given time we could do 2 enforcement actions if needed. Heaven forbid.
Well, right. But so one of the things you want to do, if you could change them, would be to put in a provision that says 2 things. One is, if you don't pay and I have to take action, you pay my attorney fees for the association, and I can lien the property to collect.
Yes, and we do that. We regularly give people a 3-year period in which they cannot pay, but if they don't, then we do have put
You have the lien right.
liens on properties. We do
Right.
that.
Those are effective enforcement mechanisms. I mean, condo associations use them all the time. They're certainly legal for homeowner associations as well. And a provision for attorney fees is definitely highly recommended.
Okay.
Because it doesn't cost you that, it costs them.
Our deed restrictions do include the language that we can collect, that is mandatory, and that we can put liens on properties. So all that is covered by.
It shouldn't have cost you anything then. I don't understand why it would have.
Well, you get to pay for attorneys. Oh, well, it's the issue of covering your own attorney fees. That was not covered in the action.
You need to, the attorney fee provision should be saying you're going to be paying the association's attorney fees in addition to the amount that's owed.
Okay.
And so that the net should be you get your fees, you get your dues, and you're not out the fees. The violator should be paying that. That's
all this went to negotiate. The initial step in the deed restrictions is we go to arbitration. There's no provision in our deed restrictions for that to be anything other than split between the association and the
right. You should change that, because that is affecting everyone in your association adversely because of one recalcitrant individual. That's not fair.
Okay. Okay, thank you. That's
Sure.
worth the price of admission.
Right. Yeah. Let's see who I know. There are other hands up here. I see Brian. I don't see a last name.
Yeah, this is Brian McCormick I'm the vice president in Chapel Hill Estates.
Okay.
We're voluntary. We have about 50% or so of 160 homes that volunteer to pay a small fee, and we host an annual summer party and do Christmas lights and stuff. We don't do a lot, but we're paying attention to this because it can have a big effect on our homeowners association and all of our properties.
Yes.
So that's why I'm on the call. And my question was, how exactly do I find these deeds? Are they on my property, or if we're a voluntary organization, they're not going to be something that's on the association somewhere? Because
no, they are recorded against every lot in the subdivision, and you can find them by searching the records. The easiest way to do it is to look up your closing package, contact your title company, and ask them for a copy, because you'll have the library and page referenced right in the policy.
Okay.
And they can then give that to you. The other thing is, if you can find that document, you could get on a public site for Oakland County and the Register of Deeds office there, type in that library and page and pull up a copy that way as well. But you'll need to find reference to the library and page. That will only be in your title commitment or title policy.
Okay. So yeah, I guess calling them is the fastest way to find it. Otherwise I look through every single page until I find what I'm looking for.
Well, they won't be in your closing package. They don't give them to you naturally. You have to ask for them. So it'll be referenced in your title policy. When you get that policy or the commitment, they'll say they're at such and such library and page, but you have to request the actual document, which could be, 15, 20 pages long, could be 5 pages long. I don't know how old your sub is. And there may be amendments, you never know. So you want to get everything that's referenced there. And, and that's your starting point. That's certainly a good place to start. And, you know, maybe there's a repository among someone in your association who has a copy and you can ask them.
I will certainly do that.
Okay. I see Harris has
Thanks.
a hand up.
Yeah, I'd kind of two questions if I could. One was you talk about modernizing the deed restrictions, right? And our deed restrictions are 100 years old or pretty close to it.
Sure.
There's provisions to remove restrictions with 3/4 of the lot's approval.
Sure.
But what would it take to add restrictions? Is that 100? Do you need every single owner then to be able to do that?
I would have to read your deed restrictions to answer that. To amend them usually is, like you said, 3/4 on your particular document. Everyone is different. Some are 2/3. Adding new restrictions would probably require a unanimous vote. If it hasn't been contemplated, changing one from no sheds to only a shed of this size, this material, you know, and only one, that kind of thing, that's not going to require 100% vote. That's an amendment. But adding a restriction that was never there before, you know, for example, we're not going to allow privacy fences unless you have a pool. That might require a unanimous vote. And again, I would have to read your document to determine that.
Right. Okay. That's good.
Okay.
And then just for clarity, right, if you can talk a little bit about the difference between deed restrictions, bylaws, and then also rules, right? Because the deed restrictions are kind of give blanket approval power to the association. And then
They do.
Yeah, just how that would manifest itself in whether it's rules or other policy documents, or, you know, how that would happen within an association.
So ordinarily you get a deed restriction that's part of an original plat that the developer records at the time he's platting this property or shortly thereafter. In it, he'll designate that everyone who buys a lot becomes an automatic member of an association, for example. And that association then will be incorporated at the state level, usually on a nonprofit basis. And it will then have bylaws that will govern how it operates, how its members are voted, what kind of officers you will have, what kind of authority they have, how often there will be meetings, whether they will put together a budget, whether they'll publish that budget, those types of things. And it may give them in either of those documents, rule-making authority. For example, if there's a community pool, it may say, we're only going to allow guests or residents to use the pool until 10 o'clock at night. That kind of a rule is something that the association has the authority to pass in regulating the use of a common element, for example. And that's where that would come from. You would not find that. It might be in an actual building use restriction that those hours are there, but unlikely. And it would be something that, as part of either the bylaws or a rulemaking process governed by the bylaws, that someone could pass. I hope that answers you.
Yeah, no, that's helpful. And then just an extension to that, right? So a lot of our deed restrictions in Bloomfield are, 50 to 100 years old, right?
Yeah.
Just when the neighborhood was developed.
Right.
And a lot of the restrictions are old and don't contemplate kind of all the air conditioners, the pools, the sports courts, the fences. Like how
Sure.
Have associations managed that over time, given that they have such old deed restrictions?
Well, a number of different ways. First of all, you do have local ordinances that, when there's pools involved, for example, that will dictate certain things like fencing. And so that will, in some ways, trump an old ordinance that prohibits fences altogether, when for safety, you have to have at least a 4-foot fence that, a child's head can't get through or something like that, by ordinance. So a lot of times you'll update the restrictions to kind of mirror ordinances that you have, but you really want to tailor it to what your community needs are and community requirements are. If you've got a community pool, for example, you may want to limit its use till 10 o'clock at night to prohibit teenagers and noise. I mean, that's something you can do. So it really is a case-by-case basis. you know, some of it is going to be elimination. You know, you're not going to have to worry about slaughterhouses and livestock in, you know, that 100 years ago was a real problem, you know. But in a modern subdivision, you're not going to have that kind of a thing. So there's a number of different things you can do, and it all is based on what your community wants and what people's ideas are there. So there's a host of things to visit with. It's not something that's carte blanche for everybody, you know. I see Susan. Oh no, it's not Susan.
Yeah, this is Mike Smith.
Right.
And I'm from the Westchester Village Homeowners Association. And on the line here today, I see is Jeff Schultz also, who's the president of our Homeowners Association. And the question I have is, our subdivision was started back in the mid-50s. And it was developed over a period of time, and we have 4 sections of Westchester Village.
Sure.
And they each have their own different deed restrictions. They're close and very, you know, similar, but there are sometimes some minor variations. For example, back in the 50s when we were first developing, colonials were prohibited. Everything had to be a ranch.
Sure.
But back in 2003, the deed restrictions were updated back in that time to allow for colonials. Now, my question is, the other section is still under the original deed restrictions from back in the 50s. Now, do we need to redo all of our deed restrictions, or just that one that's really old? Because I don't know, as far as, and Jeff might know this a little bit better, when it was changed in 2003, whether or not it was modernized at that point in time and to include all new elements.
Well, let me ask a question real quick. You're telling me that there are 4 sections with 4 different sets of restrictions, but one association administers all 4 sets?
Yes.
Okay. So obviously the developer, when they were doing that, had different goals in mind for each kind of section. And maybe those goals are no longer viable or valid. And you know, you can revisit if you want. I don't know if, for example, the older part of the subdivision is now subject to, you know, redevelopment, where you see, for example, in Birmingham, people build these, you know, complete footprint houses that take up the whole lot. If you're experiencing that and people want to do that, but it's restricted, then maybe it is time to visit that. If that's not happening there and everyone's happy with it being a ranch, maybe the goal of the developer is still valid and you want to keep it enforceable. It's all about the intent of the people in that particular sub and what they want. You see, Jeff, you wanted to say something?
Yeah, let me just follow up what Mike was saying. The one of the 4 that was not changed in 2003 was because in the original, it wasn't the oldest sub, it was one of the newer ones. And they, for some reason, allowed 2-story homes.
Okay.
So that wasn't, so that was not changed. The other 3 were in 2003. And I think I had the same question. So if we just refile the ones from 1957, would that then bring us into compliance so that none of them are 40 years old?
That's correct. That's absolutely right.
Okay, so.
And that was, if we still were under the restriction of March 29th of this year, without having had that, you know, less than a month ago reprieve, we would be doing exactly that, recording the old ones, because there's no time to revisit and modernize these restrictions, you know, in a month or a month and a half or 2 months. It takes longer than that. And so we would simply re-record with, it's called a notice of claim. Okay, under the statute, you've got to have certain details in it, including all of the tax ID numbers, all of the owners' names, all of the lot numbers, and legal descriptions. And then you have to set out the details of the claim, including the labyrinth pages of all the building and use restrictions. And I recommend attaching them and re-recording them. And that's what you would do. And then you would not have to worry about this again for another 40 years.
So you're saying that even the ones that were changed in 2003, we need to file a notice of claim for?
No, just the one that hasn't been touched. The ones that were recorded in 03, they were just recorded. you know, just a short time ago, you still have time. That's within the 40 years and you're fine there. So you don't have to do anything as long as you recorded those properly. I mean, I would look at the recording for you and tell you if you did it properly. But that's really what it is. William, you've had your hand up.
Yes, I have. I'm Bill Barrett. I'm in Adams Square subdivision, and we amended and passed our deed restrictions back in 2007. Are
Okay.
they viable?
Oh yeah, that's only 13 years ago. You're well within the 40 years. You're well within the 40 years.
Thank
Yeah.
you for that information. I appreciate it.
And let me say this to you. One of the reasons that we are asking the people who are behind this legislation to amend it and make an exception for condominium associations and homeowners associations is because, you know, this type of institutional history might not exist, you know, in everyone. And someone may not remember that it's been 40 years, we've got to re-record something or we lose these restrictions. There's turnover in that time. And so it's really not, it's not something anyone anticipated, but you know, you have to be vigilant about it. Do it now and hopefully pass along the institutional knowledge to the people that take over from you after that. But hopefully they'll make an exception and we'll see. Robert Lysecki, I think you had your hand up.
Yes, can you hear me?
Yes, I can.
Okay, thank you, Stephen, and you actually did get the last name right. My thanks or congratulations. So, kind of two questions. We updated our deed restrictions in 2011.
Okay.
You know, good. But I was new to the board like 5 years ago, but I was reviewing records from the time, and I know their hurdle for passing those amended deed restrictions was 51% of the property owners.
Oh, good, low bar.
And I know that they had legal opinions from an attorney from a firm that said that was the hurdle. So early on, you said 67%, but then you later said it depends on what the deed restrictions really called out. So
yes, every deed restriction is going to be different. It might be 51, it might be 66. There was another gentleman, I think, referenced 3/4. It could be unanimous. I mean, it all depends on what the document says. So,
okay, great.
So if you've got a legal opinion you're relying on, you're probably safe.
Yeah. My second question was whether the property owners association is voluntary or mandatory. I know our tribal wisdom in the subdivision says ours is mandatory, but when I read the bylaws or the deed restrictions, it doesn't really come jumping out at me that it's mandatory. Like we generally don't put liens on property because there's nothing in there that says about liens. But
Right.
if you want a copy of the directory, attend the party, vote, or do any of those things, you have to pay our $50 a year.
Right.
So,
right. So there's two different things here. It is absolutely mandatory in every single association that you are bound by these restrictions because you are bound by virtue of buying property in the subdivision. That part is mandatory. What I was referring to earlier is what you just described right now, which is paying, whether paying is mandatory. And that would have to be explicit in your building and use restrictions. It would have to say specifically that the association has the right to lien and enforce. They can, you know, by vote, change the amount of the assessment for good reason after a meeting and notice. That kind of thing is usually standard when it's a mandatory pay situation. So you're doing the right thing. If you've got a voluntary pay, like it sounds like you have, you're simply saying, well, if you want the benefits of the association, you have to pay the dues or you don't get.
Mhm.
And that's certainly one way to make it enticing for people to pay. And it's a nominal amount. You know, if you've got a private road, for example, and you've got to maintain that, that's going to be really hard to
Right.
do with a voluntary association because no one's going to want to pay it. And especially if they're the other end of the road and they don't use it, I mean, it's going to be really hard. And I've seen that happen. And I've seen two homeowners associations, one next to the other. The second one has to go through the first one, and the road is destroyed in the first one, but the first people won't pay for it because the second sub uses it all the time. So now you've got a dispute between the associations, and it's a problem. So, you know, that's something you could visit if you were having those issues, but it doesn't
Okay.
sound like you are. It sounds like you're doing a great job.
Yeah, we're getting about most people pay, let's say within 3 years, we get about 80% plus people paying, so.
Oh, that's good. That's
Yeah.
good.
Okay, thank you very much.
No problem. I think I see Celia has a hand raised.
Yes, I do. I got a
Okay.
couple. Earlier about that shed. What happens when the township overrides your bylaws? And
Well, they don't. They cannot.
You can't do that.
They can't do that.
Well, I've had that problem. They used to let you know when somebody would put in a permit
Mm-hmm.
and let you know if they were going to build something without
Sure.
letting the division know. Well, they don't do that anymore.
Well, understand there are two different things here completely, and they're actually really not that related. The fact that the city would permit them to do something is only a zoning issue. They're going to say it meets side yard and rear yard setbacks. It meets our structure requirements. It will have a foundation. Hey, that's all great. And you satisfy our requirements and we get to inspect and collect our fees. That has nothing to do with your restrictions that say, you're not going to put a shed there. And so if they start to build and say, hey, I've got a building permit, you say, guess what? I've got a deed restriction. You're not going to put that shed there. Take it down or I get an injunction and you'll win.
Okay, well, we only collect $55 a year for 29 homes. We don't have a lawyer. Do we come to you for help? Or do we
Well,
have to
sure.
hire ourselves?
No, you would definitely want to hire a lawyer to enforce that. That's not going to be something that I don't think you would want to handle on your own, because they will certainly get a lawyer to defend against it. And like you say, though, if you're only collecting that much money, I mean, how much enforcement ability do you have? Because the fees could get more than than you've collected. You know, how tough does the association want to be? This is the type of thing that you want to address now. This is where you have a meeting with your constituents and you say, hey, look, here's our real problem. People are going to go out and they're going to do this because the city will give them a permit, but we have rights and we have property values that we want to maintain. We should be amending to either collect more money, make it mandatory that if you're not going to increase, that the violator pay the attorney fees and that you have a lien and injunction rights to enforce it. That's the type of thing that I'm encouraging you to do right now, because it's very difficult to finance this on $55 a month. You know, I don't know how many homeowners you have, but.
Well, and we're voluntary. And then the next thing, there's two of us, a president and a secretary.
Okay.
And I've been president basically since 1990. And so is my secretary. A long time ago, you recommended that our board members get insurance to protect us from liability.
Mm-hmm.
Do you advise us putting that in our bylaws that are
I do.
mandatory with our dues, that we would be covered?
Yes, absolutely. I do. I recommend that to every association that you have director and officer coverage so that there's no liability. In fact, I would put it even more in the bylaws. I would put in that there is no responsibility absent fraud, you know, some lack of business judgment, some type of egregious behavior, so that you aren't facing, you know, individual claims when you try and enforce a shed rule and the person turns around and sues you for abusing your authority or something like that, and you have no coverage. Okay. So I mean, that's not fair, and it will cost you money that shouldn't cost you for enforcing property rights to protect values.
Okay, and then about liens, I always understood that if it wasn't in the bylaws, you can never put a lien on somebody's house as against the law. Is that correct?
You are correct.
Okay, all right.
You are correct. I mean, absent a construction lien, we're talking about liens by associations, right? I mean, there's other laws, but an association has no right to lien unless given that authority in the deed restrictions that are recorded.
Do you recommend us working with a lawyer as we're doing our bylaws, as I try to get a group together in my subdivision?
Absolutely. Absolutely. Unfortunately, with Zoom, it's difficult, but it can be done. And this isn't the first meeting of this size that I've had. I've had several meetings with 40 or more people on. questions like this, and we go through, make a presentation of what we'd like to see. You circulate the documents in advance, and hopefully you get some consensus among people wanting to keep their values high.
Okay, and I could get recommendations from the United Homeowners Association on attorneys?
Sure, absolutely.
Absolutely. Okay.
Okay.
Thank you very much. When's our next
my-
meeting about this?
My pleasure. Let's see, anyone else with a hand up that I've missed? Harris, did you have another question, or is your hand still just up?
I did. No, I do have another question, actually.
Oh, okay.
One is a comment too to Celia's note about the township. Actually, they've been really good about notifying us of any building permits that go in that haven't been reviewed by our association. So it may be a situation where you just may not have the right contact information in at the building department. But the township's been, they always work with us.
Sure, good
very
point.
well, so.
Celia, you might have experienced your problem as a result of you not registering yourself, your association, with the township. Now, they have promised that they will make one attempt and one only to reach the association when they're going through the permit process. If you're not registered with the township, then that ends there. The permit will pass and will be either approved or denied on its own merit. And you will never know the difference until you see the workers show up.
Well, I am registered.
All right, good. Then that ground ball hit to you, you can snag it at that point, and you can catch it before it becomes a problem, other than chasing the problem after it's complete.
I think it was just one time
Celia,
mistake.
you should probably contact the building department and make sure you're on however they contact people. That may be the issue.
Yeah, sure.
But the township's been good about that.
There's Steve.
There's a lot of other
Harris,
complaints you can have. I do have one other question.
Yeah, okay, go ahead.
So you had talked about amendments, right, to the MRTA, and there's a House Bill 6332 was actually introduced in November, right? That would, as you said, right, the condos and subdivisions would be waived from this this requirement.
Right.
What's your thought on like the possibility of that actually moving through and being passed? Right. I'm just.
I actually think it's probably likely. I've talked to one of the people who's worked on this bill and the original bill, and he said it was never intended, to have this effect. So I do believe they're going to try and correct this for everyone. But that doesn't mean that we shouldn't take the opportunity, to make sure we've got the best building and use restrictions for the association that we manage. That's what I'm suggesting. Yeah.
Right. Yeah. We got to make sure the structure and everything's sound for us.
Yeah, exactly.
Have the neighborhoods we want.
Right. Exactly. Okay. I see a gentleman named Harry. You have a hand up there?
Yeah.
Yes.
This gets back to what's the, oh, there's another Harry.
Oh, there's two Harrys. There's a Harry Jones and just someone who says Harry who's down here.
Who wants to go first?
Go ahead, Harry.
Okay, Cecilia, you can get a hold of George Kilpatrick over at the township. And if you need his number, you can look it up on their website. He's the building official. And as long as you get with him and he knows who you are, anytime, has been said, if somebody wants to have a building permit for anything in your community, he will send you a notice and give you 2 weeks to either respond back to him that it's against your building and use restrictions or your bylaws or whatever else. And if not, he goes on and handles the building permit as per the township's ordinances. So if you get with him, it works out fine. He's got a list of a mile long of all the people he contacts that when a building permit comes in from certain areas. So he's a good guy to work with. George Kilpatrick.
Okay. All right, Harry, number 2.
Since there was a glancing blow on D&O insurance, just one quick question, because our insurance is coming up right now. We have got $1 million coverage for D&O insurance. My concern is that's woefully short term. We have 42 homes here in Bloomfield Chase.
First of all, is it $1 million per incident or in the aggregate? Would be the first question I'd have.
Okay.
So you can get an umbrella policy above that as well. And that would be a lot cheaper than increasing your limits.
Okay. Sorry to interrupt the discussion.
No, that's quite all right.
Good question.
Jim Page, you've had your hand up for a while.
Yes, just in quick response to the question about the officers and directors insurance, we get it through the United Homeowner Association, and it's a $5 million in the aggregate coverage.
Oh, there you go.
And because it's kind of a group policy through the UHOA, it's reasonably well priced. It's like $570, and we have 66 homes in our association.
Great.
Just another question also to follow up on the working with the township. The township has also been very good with us, and they always notify us when any building permit is applied for. And one other comment goes back to a question earlier about where do we find the deed restrictions. We do have a website for our homeowners association, and we post a copy of the deed restrictions and the bylaws on our website under the members section. So that
that's an excellent idea. If anyone else has an association website, I would encourage you to post them there. That makes it available for everybody. Easy reference if they want to see it. Good, great idea. Thanks, Jim.
You're welcome.
One thing that we advise on the website, when you post your deed restrictions, put it in front of the password, not behind, because the new buyer coming in should have access to it for an informed buying decision.
Okay. Jeff?
Oh, thank you. I apologize. I can't find that chat, that hand raising button anyplace.
I saw your hand going up. No problem.
Thank you. I appreciate that. But I want to go back to the shed thing.
Yeah.
The shed issue is, first of all, if that person who built that shed didn't get a variance from the township through the ZBA, then the township can cite them for not getting a permit for that.
Assuming it does not comply with
structure.
Assuming it doesn't comply with the ordinance in some way.
Sorry?
They may not need a variance if it complies with the ordinance.
No, the ordinance doesn't allow an accessory structure. You have to get the variance for it.
Okay.
And so if you don't go to the ZBA to get the variance and you build it, if you talk to the township ordinance person, Joe, I forgot her last name, they will go and check it and then make you get a permit for it or get a variance.
Sure. But again, that variance will not justify violation of the restrictions.
Well, that's two separate things. The township would say, yeah, you can build it, but then we'd have to sue them.
That's exactly right.
Experience with this because we have 462 homes here. There's something going on every week. And every time there's a ZBA, we get somebody who wants to do something.
Sure.
And the township has always notified us in every single case, and we have an opportunity to make a comment. And most of the time, they would agree and either whatever we ask. But they don't have to. They can do as long as they meet the ordinance, they can override us, and then we'd have to, of course, like you said, go and sue. But the shed itself is an accessory structure. That has to get a variance.
There you go.
Period.
Yep. Very good. All right. Anybody else? Let's see. I see Cameron.
Yes. On the issue of putting the deed restrictions on the website and the rest of it, that's an excellent idea. One thing that we do, which people might find useful, is that when we have a homeowners directory, and in the homeowners directory, we also include the deed restrictions, including the library associated with it. And also at the annual meeting, we always reference the deed restrictions, reminding everyone that participation is mandatory, that it's not voluntary. And the purpose for doing that is so that everybody's aware of it. It's there's nobody can ever claim that there's it wasn't advertised and it wasn't when people weren't aware of it. Is there a requirement at the closing that the title companies actually distribute the deed restrictions? I mean, it seems like it should be required.
It's not required. They have disclosed it. And like I said, a lot of times there's an embedded link in the commitment where you can pull them up just by clicking on it, but they're not required to give it unless you request it. But they will do so readily and for free. They will do it right anytime you want it.
Well, as I said, we distribute it so that everybody's got a copy of it.
Yeah,
all the
no,
time.
good idea. I see, whoops, apologize. I see, where'd I go? Zoom here. There we go. Sorry about that. I see hands up, but there are hands that have already asked a question. Unless there's more questions, I think that's pretty much everybody.
I have
All
a
right,
question.
thank you very much for allowing me to come and speak to you. I'm happy to answer any questions offline if you have them. Reach out to David or Richard. They can give you my number, and I'm happy to talk with you.
Well, Steve, we want to thank you for your time this morning and the advice that you've given us. If any of the members that have talked to you would like to get more information about the United Homeowners Association, you can contact myself or Dave McGinnis. Thank you for your time.
My pleasure. Good luck to all of you. Have a great day.